Yes, Mr. Jockey.
Hey, please, you lady, lads. I appear together with Mrs. Alexia Robinson and instructed by Sheridan's for the intervener, the Jamaica Employers Federation. This is an appeal from the decision of the Jamaican Court of Appeal handed down in October 2012, overturning the decision of the Supreme Court, Justice Mangatal, who had ordered that the award of the IDT be quashed on a number of separate and independent grounds. University of Technology is not here today and is not participating in the appeal for a number of reasons, including funding and other related matters.
Well, we understand that you, as intervener, have basically taken over the appellant's case.
Yes, indeed we have. And, of course, you have also seen the position of the respondents and that they are not participating in this appeal. But I see that I was handed this morning.
Well, we were handed it late last night, yes, Mr. Goffey, so that's why it took so long to get to you. But we took you at your word when you said that this was a very important case for employment law in Jamaica. And we thought that although we had the benefit, of course, of the judgments in the courts below, it would be helpful to have some further help with what the respondents might have argued were they here. So that note has been produced by one of our judicial assistants. We understand that you might like to make written submissions in response to it.
Possibly, milady.
Well, possibly. See how you go.
We'll see how we go.
Yes, yes, because the issues are not unfamiliar. And, of course, you must confine yourself to the issues in the grounds of appeal.
Of course.
Yes, thank you.
I also wish to note, though, milady, that the respondents, especially the first respondent, the Industrial Disputes Tribunal, I think perhaps knowing that they would not be here, they made sure that the record, the transcript, and their arguments in the Court of Appeal are included in your bundle.
Yes.
I point that out because there is a stark difference between what the case and the points being presented in this note we got this morning and the arguments that were actually advanced by the IDT below. So, in a very real sense, these are all fresh arguments being made for the very first time before the Privy Council.
Well, that's a point you can make.
Yes.
I mean, I think one should point out that it's quite customary for us when only one side is arguing the appeal to ask one of our judicial assistants to prepare a note such as has been prepared in this case. So there's nothing unusual about your particular case.
We certainly are familiar with asking counsel to...
actus and amicus, yes.
Yes, and normally in that case, I think we would have had a chance to see it much before last.
Well, I think my lady has explained why that hasn't been possible.
Yes, very well. So the main issues that the Jamaica Employers Federation is asking the board to consider is firstly, whether when determining whether dismissal is justifiable or not, is it proper that the Industrial Disputes Tribunal can consider material that was not available to the employer? And certainly we say that it should not.
But it
should not.
Should not.
It should not consider that material. The only context in which it should be able to consider that material is in connection with the appropriate remedy that they might award after making the determination that the dismissal was unjustifiable. And particularly, we'll see that that's where Ms. Spencer's passport features quite prominently in our case. Second issue, and specifically in the context of misconduct cases, is it a requirement that the employer should satisfy the IDT that the misconduct in question actually occurred, or that it had reasonable grounds for believing that it had occurred? And we say that the test must be whether there were reasonable grounds for believing the misconduct had occurred.
Basically, you say that the role of the IDT is to consider what did the employer know, or perhaps reasonably ought to have known, at the time of the decision in question, and did what the employer know or ought to have known afford reasonable grounds for the dismissal.
Precisely.
That's basically what you say the situation ought to be, yes. Which would, of course, be the situation in the law of England and Wales.
Yes, it is, and other places as well.
Yes.
And that's what we're going to go and look at and see why it is that in the Jamaican context it should be different, and why it should suddenly be different. Because as we will go on to show that we have a long history of relying on English unfair dismissal cases and tests. And so what has happened in this case is actually a departure. It is actually a change in the way that we always understood the IDT's role to operate. It has replaced what we always understood to be the case. And thirdly, in assessing whether the employer's reasons for dismissal are justifiable, should the IDT apply the standard of the reasonable employer, or ask itself whether it would have acted in the same way that the employer did? And of course, we say that it should be applying a reasonable employer standard. And therefore, even if the particular tribunal would have adopted a different course in those circumstances, that does not necessarily make it an unreasonable course for the employer to have taken. In other words, unjustifiable doesn't simply mean that the IDT would have acted differently. I think it's important to understand where we're coming from in terms of how our jurisprudence has grown up. And I've put it in the case that we will see that our unjustifiable dismissal legislation has its genesis in the Donovan Commission report. And it was essentially rolled out throughout the Caribbean region, starting with Jamaica and Trinidad. The point being that we were always keeping an eye on the way things were being done in England, at least right up until 2012, when we had our own Brexit of sorts. Decided that we would go differently. But the point that I want to emphasize is that although the statutory structures actually differ, the underlying intentions remain the same. And they flow, in part, not only from English law, but also from the International Labour Organization conventions and recommendations. And in our context, it's a two-stage test. That firstly, termination of employment should not be allowed unless there is a valid reason, which is itself reasonable in the circumstances. And secondly, that the procedure must be fair. Now, the closeness of the relationship between England and Jamaica in terms of unjustifiable dismissal and unfair dismissal is readily apparent even in the Labor Relations Code itself. Section 22 of the Labor Relations Code
Where do we find that?
Page 1748, my lady. 1748.
1748. Thank you.
That's in the fourth volume. No, it's in the authorities. Page 1748, Section 22 of the Labor Relations Code speaks to the disciplinary procedure. In brief, my lady, my lords, it says that they should be agreed between management and workers to ensure the fair and effective arrangements exist for dealing with disciplinary matters. The procedure should be in writing, should specify who has the authority to take various forms of disciplinary action and ensure that supervisors do not have the power to dismiss without reference to more senior management. Should indicate that the matter giving rise to the disciplinary action clearly specified and communicated in writing to the relevant parties. Should give the worker the opportunity to state his case and the right to be accompanied by his representatives. Provide for a right of appeal, wherever practicable, to a level of management not previously involved. And it should be simple and rapid in operation. You can also point out that it speaks about the procedure. There should operate as follows. The first step should be an oral warning, serious misconduct, a written warning. No worker should be dismissed for a first breach of discipline except in the case of gross misconduct, and so on. That might sound very familiar to you. It comes almost directly from the ACOS Code. If you turn to page 1956, this is the text, Industrial Relations, Law and Practice in Jamaica, by Mr. Kirkcaldy. I should say, my lady, that at the time that this case was being heard by the IDT, this text was the only text on industrial relations law in Jamaica. So you can see the ACOS Code of Practice states that disciplinary procedure should not be viewed primarily as a means of imposing sanctions. It should be designed to emphasize and encourage improvements in conduct. It goes out to point to that disciplinary procedure should A, be in writing, B, specify to whom they apply, C, provide for matters to be dealt with quickly, D, indicate the disciplinary actions which may be taken, specify the levels of management which have the authority to take the various forms of disciplinary action, ensuring that immediate supervisors do not normally have the power to dismiss without reference to senior management, provide for individuals to be informed of the complaints against them and to be given an opportunity to state their case before decisions are reached, give individuals the right to be accompanied by a trade union representative or by a fellow employee of their choice, ensure that except for gross misconduct, no employee is dismissed for a first breach of discipline, ensure that disciplinary action is not taken until the case has been carefully investigated, ensure that individuals are given an explanation for any penalty imposed, and provide for a right of appeal, and specify the procedures to be followed.
How does the internal university disciplinary procedure in our case arise on this appeal?
In this appeal, the internal disciplinary procedure was triggered, and there was a disciplinary hearing which Ms. Spencer and her union were invited to attend.
Yes.
And witnesses attended on behalf of management. I should indicate that the disciplinary panel is comprised of a number of representatives from various bodies. So somebody from council should be there. One of the employees' peers is also to be on the panel. So it's not simply a situation where the immediate supervisor or the head of the department has the power to make that decision. And in this particular case, there were witnesses who testified as to what had transpired from their perspective. And based on the evidence and the conversations with Ms. Spencer, what their understanding of her position was. And the union did not attend. And Ms. Spencer did not attend. Much was made of that by the Industrial Disputes Tribunal. And when it went before Justice Mangatal, she gave a number of reasons why the university would have been correct to have proceeded with its disciplinary hearing, even in spite of their absence. So it does feature in it in that at the beginning of the Industrial Disputes Tribunal hearing, on the very first day, when we pointed this out to the chairman and said that, you might wish to review the evidence and the material that had been considered by the internal tribunal. And his response was blunt in that they are not concerned with what the internal tribunal did. Those were his exact words.
You're not still arguing, are you, that because Ms. Spencer didn't give evidence before the internal disciplinary hearing, the tribunal was wrong to allow her to give evidence before it?
We actually never argued that.
You didn't?
No.
Then I misunderstood.
That is what the Court of Appeal said. But if you look at page 209, you will see the actual argument that was made. And this is the transcript now from the Industrial Disputes Tribunal hearing. I'm afraid that the transcript isn't quite verbatim. I think my grammar is a little bit better than it's represented here. But it says, and I'm starting now at line 13, I think it is.
Yes.
And this was the, I think this was the opening.
What page was it, Mr. Goffey?
Page 209.
209, thank you.
I was saying, my lords, that my point is they did not appear, this is now the union and Miss Spencer, they did not appear to hear the reason for the charge, which resulted in the penalty of termination of the contract. They did not appear or send words as to the reason, and that would have been reason for their absence. So even if there was good reason, even if there was evidence that Miss Spencer could bring, which could force the university to say, in the light of this evidence, we now see she should not be terminated, this would have been the first opportunity that the university would have had to review the evidence. But the opportunity was not taken advantage of. So there was I'm not sure what word should be there, I don't think it's leaning. So there was a leaning to evidence from one side, and the conclusion of that leaning would therefore have been inevitable. If there was no evidence from the defense, then the conclusion would have been inevitable. So the dismissal is because Ms. Spencer did not participate in the hearing. And then Mr. McNish asks, so was evidence presented in her absence? And I responded, it was.
So what's this got to do with the decision we're making?
Well, in answer to the question, it was Justice Mangatal found that by finding that the dismissal was unjustifiable, well, let me take you directly to what Justice Mangatal said. At paragraph 84 of the judgment on page 1423, she actually found that the IDT's award was irrational because they had completely misunderstood the case that we had run.
I may be mistaken, but I had thought the point was a slightly different one. Do correct me if I'm wrong. The reason for dismissal was that Ms. Spence was absent from work without authorization. The IDT held on the evidence that it heard that her absence from work had in fact been authorized by Mr. Bramwell. And I thought the only issue was that the evidence on which the IDT based that finding included evidence, particularly from Ms. Spence herself, which had not been before the employer's disciplinary tribunal.
That's a slightly separate point, my lord. But the point I'm making in relation to whether we are still advancing that argument, I was saying that we were never advancing the argument. We were never advancing the argument that she was dismissed for not attending the disciplinary hearing.
No.
And the IDT had actually found that. They had found that we cannot sustain the dismissal of Ms. Spencer for not attending the hearing. Mm-hmm. And you can see on page 1421 of the judgment, Justice Mangatal found that this was irrational on their part, that they had completely misunderstood the case that we had run. Mm-hmm. Now, how this is relevant to the Court of Appeal is that the Court of Appeal agreed that it was irrational, but said that Mr. Goff was the one who led them down that path. And so they didn't suffer the consequences of what would normally be if a court finds that the tribunal's finding is irrational. But as I am pointing out, that was never our argument, and Justice Mangatal accepted at line 12 on page 1421, she accepted that it was never our case that she had been dismissed for not attending the disciplinary hearing. It was rather that she not having attended, we would never know what the disciplinary tribunal in UTEC would have decided on the evidence that she subsequently gave to the IDT after UTEC had closed its case. So, going back to the point about the evidence, it is not our position that Ms. Spencer should never have been allowed to testify. That's never been our position. What we were saying is, to the extent that the evidence that she was giving the IDT differed in any material respect, or worse, was contradictory to the evidence that she had given or the information she had supplied to UTEC, that it should be disregarded. Now, specifically.
And by, you're drawing a distinction between her dealings with Mr. Bramwell,
Yes.
On the one hand, and her failure to involve herself in the disciplinary hearing.
Yes. But there was before, even before the disciplinary hearing, there was a meeting between the parties, amongst the parties, on August 11th. And at that meeting, she admitted and acknowledged that she proceeded on leave without getting any approval from Mr. Grandel. And if I'm to take you to that specifically, page 18, there was the evidence.
Page 18 of what?
Page 18 in volume 1. Paragraph 17 and 18.
This is the Miss Ellis's witness statement.
Affidavit in support, Milady, correct.
Oh, it's an affidavit, right.
17 says, in a meeting held with Ms. Spencer on August 11, 2006, she admitted that she did not wait to get written approval before proceeding on leave. She had not been aware that her supervisor had signed the leave form on June 7, 2006, until after her return to UTEC on August 3, I think that should be 2006. She further said that she made an attempt to contact Mr. Martin but could not locate him at the time. Goes on, at the time that Ms. Spencer went on leave, she was aware that formal approval had not yet been given by her supervisor, Mr. Bramwell. And so the case that she had run before then, even though she did not attend a disciplinary hearing, was that she had not received approval.
Well, it says formal.
Yes, it says formal approval. The case that she ran at the IDT was that by sending her to fill in the dates on her leave application form, that constituted formal approval. Formal approval. The very first time UTEC heard that argument was when they had closed their case and she was on the stand. So she had made a complete turnaround and was saying that she did in fact have approval. She understands it. Formal approval is given once her supervisor sends her to write in the dates. And then she also testified that even though she knew that there were...
I'm just not focusing on what this has got to do with us. Is this, just explain, I mean, there are no end, we could fish about in these documents for a week and find all kinds of differences of fact.
Sure.
Whereas we're not really concerned with fact, are we? Or are we? And if so, what? It's just not quite clear to me. Perhaps you'd be kind enough to explain just how it fits into the argument today. Otherwise, we might be here until the day after tomorrow.
The principle, as refined in the SMEG case, is that an employee can bring additional evidence to support a case that they've always run. And it wouldn't be a breach of the principle that the tribunal should only take into account matters of which the employer is aware. So what we're saying is, this is not an example of that. This is not an example of Ms. Spencer producing further evidence along the same lines that she had always run. She is making a statement which is completely contradictory to the statements that she had made before.
So, I mean, is the argument that the IDT erred in law by admitting evidence from Ms. Spence about a matter as to which there had been, well, you would say, no evidence before the employer at the time when it took the decision to dismiss? Is that the argument?
It's not an erring in law in terms of admitting it, but certainly, yes, relying on it to come to the decision that her dismissal had been unjustified, certainly.
So in basing its decision on material which had not been before the employer when it took the decision which was under review, the IDT erred in law. Is that it?
Yes, my lord.
But how can it be proper to admit evidence unless there is at least the potential to rely upon it? I mean, if the IDT was precluded from relying on the evidence, Why should have admitted it?
My lord, of course, this is viva voce evidence that she's giving from the stand.
Yeah.
I'm trying to make the distinction because at no point did we say that she should not be allowed to take the stand.
Quite.
If she had taken the stand and said that she didn't wait to get formal approval and that she didn't know that she had to complete the inventory before she went off on leave, all of the different conditions that UTEC was relying on. If she had made the very same arguments before the IDT, then certainly that evidence would be admissible.
Well, quite, but I mean, you're making the case now that it was perfectly proper for her to give the evidence, but it was not open to the tribunal to rely upon it. And my question is, why, if the tribunal is not entitled to rely upon it, why could it be proper for her to give the evidence?
I think it boils down to an irrelevant consideration. At the time that she is giving this evidence, and if she contradicts herself, that is certainly something that the tribunal...
So where is the evidence she gave? Where's the record of what she said?
At the IDT? Her evidence starts... Volume 2. Actually, I can take you, for instance, to where she said that it was approval. Justice Mangatel summarizes it in her judgment. Would that suffice, or do you wish to go to the IDT record?
Well, it depends what... If you tell us, give us both, or at least give us the judges, if you have the judges.
Mr. Goff, to my mind, what you're submitting is thoroughly unrealistic. She's allowed to give evidence. She starts to give evidence. Mr. Goff gets up and says, "Sir, that's quite inadmissible. It's inconsistent with what she's previously said." Then, according to you, the tribunal has to have a big investigation, not into what she is now saying, but what she previously said or didn't say. And it has to conduct an inquiry in order to understand admissibility into what she said at previous times. I've never heard of a tribunal or a court having to conduct that. And that straitjacket seems to me, at the moment, to be entirely inconsistent with the wide jurisdiction of the tribunal.
I think it turns, my lord, on whether or not they are focusing on the reasons for dismissal. Because if you are focusing on the reasons for dismissal, and if you are telling the employer that they must go first, and that they have a burden of proof in establishing that their dismissal was justifiable, or at least not unjustifiable, if they're the ones who are going to go first, then certainly you can only judge what they have done in the context of the circumstances at the time. And it's no different. We're not asking this board to find anything different than what happens in your own jurisdiction.
Well, I wonder about that. The whole argument depends on distinguishing between Mr. Bramwell on the one hand and the employer on the other hand. If we had a situation in this country where you had Miss Spence told by Mr. Bramwell informally that she could go on holiday, and she's then absent. And her absence gets noticed by somebody more senior than Mr. Bramwell. And she is, and Mr. Bramwell says, well, she hasn't got formal leave to go, so she's called for a meeting to discuss the situation. She fails to attend the meeting, and she's then dismissed. Now, she's dismissed in perfectly good faith by the person who is doing the dismissing, but Mr. Bramwell, on the hypothesis that we're considering, Mr. Bramwell knows perfectly well that he gave her, informally, leave to go on holiday. Now, if she then were to go to an employment tribunal and complain that she had been unfairly dismissed because she's been dismissed for going on leave without authorization, whereas in fact she had been authorized, your argument is that in this country, the employment tribunal would refuse to hear evidence from her that she actually had been authorized because she didn't attend the meeting with the employer's HR manager, following which the dismissal letter was sent. Now, I'm not sure that is right as a matter of our law. It's perhaps debatable, but but you say that's not only English law, but it's Jamaican law as well.
Well, let me correct one point about Mr. Bramwell. Mr. Bramwell has consistently said that he didn't approve, whether formally or informally. He has been consistent in that. He has said that when you spoke to me about 12 days leave, because that was on the leave roster. I learned for the first time that you were taking 34 days, or you wanted to take 34 days, when you were already gone, and I picked up the leave form, which was unsigned.
Yeah.
So his position is that I have never given you.
Yes, it doesn't really turn on his position.
Yes.
The tribunal accepted Ms. Spence's evidence that he had given her informal approval. And your complaint is that you say she shouldn't have been allowed to give that evidence because it was something which hadn't been known to the employer at the time when she was dismissed.
Let me go to the position in England, because it is very clear, I think, on the position in England that she would not, the court would not, the industrial tribunal, the employment tribunal as it now is called, would not have allowed her to testify.
But what has the position in England got to do with it?
The position is that to the extent that there are similarities in the way that the tribunal here and the tribunal in Jamaica conduct their review, and to the extent that the statutes that underpin them don't prohibit it, that if the employment tribunal in England wouldn't allow it, we'd need to find some compelling reason why the employment tribunal in Jamaica should. So I'm starting from the position that the employment tribunal in England most certainly would not allow it. Starting though with, on page 1418, at paragraph 76. Actually, let's start at 1408. At paragraph 60, we have the case of St. Anne's Board Mill Company and Brian Kelly et al. The facts: the respondents were dismissed from their jobs as cable pullers because they refused to act as mates to an electrician, Mr. White. They believe that Mr. White had been responsible for an accident, but the employers, following an inquiry, concluded that another electrician, Mr. Randall, had in fact been responsible. The tribunal, on the basis of the evidence at the hearing, decided that Mr. White had been to blame and that the cable pullers were not therefore unreasonable in refusing to work with him and that accordingly they had not been dismissed for any of the reasons within Section 24(2) of the Industrial Relations Act, England, and their dismissal was therefore unfair. The appeal was against the tribunal decision, and the NIRC allowed the appeal. They held the tribunal had misdirected itself in deciding that the case turned solely upon their view of who was responsible for the accident, and drawing the consequent conclusion that since a man with whom the respondent's employees had refused to work was responsible, the respondent employees were not unreasonable in refusing to work for him, and accordingly were not dismissed for any of the reasons within Section 24(2). Respondent employees were quite clearly dismissed because they refused to obey the employer's instructions, and this was a reason relating to the conduct of the employees within the meaning of Section 24(2)(b). The tribunal should have so concluded. The tribunal should then have considered whether the employer had acted fairly or unfairly within the meaning of Section 24(6). And that subsection requires the tribunal to consider whether the employer's action was fair in the context in which it was taken. The moment of time at which the employer's action has to be considered is the moment at which he dismisses the men. And the question of whether the employer acted reasonably or unreasonably in treating the reason as sufficient has to be answered with reference to the circumstances known to the employer at the moment of dismissal, or circumstances of which he ought reasonably to have known at the moment of dismissal. In deciding whether the employer behaved unreasonably at the time of dismissal, it was not permissible to take into account circumstances which came to light long after the dismissal, of which the employer neither knew or ought reasonably to have known. Before dismissing the respondents, the employers had made a careful inquiry into the circumstances of the accident and had formed a bona fide view based upon cogent evidence that the person to blame was a man who admitted responsibility and not the person with whom the respondents refused to work. It followed, therefore, that their only course was to dismiss the respondents, and their dismissal was fair. There are at least a dozen other cases, my lord, where that point is emphasized, that the moment of time that matters in unfair dismissal cases is the moment of time at which the dismissal is actually made.
So are you equating a question whether the employer acted reasonably with whether the dismissal was unjustifiable?
We are. We are saying that if an employer acted reasonably, then the dismissal, subject to the procedural elements, which don't arise in this case, that the dismissal must be justified. You can't be reasonable and unjustifiable at the same time.
That's quite a nice line, Mr. Goff.
And this works both ways. It works both ways in that an employer cannot rely on information that comes later to justify a dismissal. And an employee cannot rely on information that comes later to say that the dismissal was unjustifiable. So both are constrained by the same cutoff point. And that's why our Labor Relations Code places such great emphasis on having the disciplinary hearing. It says that you are to have the hearing, let them know in writing in advance, let them be accompanied by a representative, let them even have an opportunity to appeal. Because that is the moment in time that really matters.
But you say the information that comes later. I mean, if an employee is seeking to demonstrate that her employment has been unjustifiably terminated, surely it's open to her to produce evidence to that effect as to the contemporaneous events, even though it may not have been present to their mind or may not have been drawn to the attention of the employer at the time that the decision to dismiss was taken.
I think it's open certainly at the point of the disciplinary hearing. Now, because that's...
But doesn't it... my Lord may be putting to you, I'm not entirely sure, that the employee should be permitted to give an account of what the employer knew or ought reasonably to have known at the time the employer's decision was made.
Absolutely.
And arguably, that is the situation in this case.
Well, we say, my lady, it is not. That on the facts of this case, this is not a case where she was saying that Mr. Bramwell knew that he had given me approval. What she is saying is that I have interpreted the fact that he sent me to fill in the dates as constituting approval, whereas before she had said, I didn't have formal approval. I should correct that statement. She was treating the fact that she was sent to fill in the dates as formal approval.
Well, she was treating it as approval.
No, formal approval. That's what her evidence was.
Well, maybe, but why do you need formal approval? What's wrong with approval?
Well, we're simply saying that at the time that she was invited to make representations of this nature, she didn't. And it may well be that the tribunal...
Well, let's assume that. So what?
Well, based on the law in England...
Well, what about based on the law of, well, we're actually concerned with, namely Jamaica?
I think this...
Notice the flag.
Yes, I noticed the flag. Well, let me start from and show how we have graduated and adopted the English principles in Jamaica. In Post Office and Jones, that's at paragraph 76 of the judgment.
This is 76 of whose judgment?
Justice Mangatell's judgment.
Well, do we find Post Office and Jones in your authorities? That might be helpful.
No, it's not in there. We heeded the warning not to produce too many authorities, and so we didn't.
I think you're probably permitted to include the authorities that you're going to refer to.
The Post Office and Jones, the essential aspect of it is captured in the judgment, paragraph 76, page 1418.
1418?
Yes, my lady.
Yes, of course, yes.
And in that case, it says that though the normal effect of a failure by an employee to respond to an invitation to make representations as to why he or she should not be dismissed would be fatal to the employee's case of unfair dismissal, in the present case, the respondent should not be unduly penalized because of the unfortunate advice that she had received from her union representative. So we're setting as a general rule that if we have set up this regime for you to make representations and to show why you should not be dismissed, and you fail to respond to that invitation, then unless you have some extraordinary circumstance, the normal result will be that it will be fatal, is the word, to your complaint for unfair dismissal. Likewise, in Jamaica, because what the tribunal is to be examining is the reason for dismissal, because they are forcing employers to go first and imposing on them a burden of proof, that burden of proof could only be in the context in which they were aware. If it were a wrongful dismissal case, it would be different. And of course, in a wrongful dismissal case, the employee would go first.
I just wonder, in a situation where the disciplinary offence is going absent without the approval which you ought to have got from your supervisor, whether the employer ought not reasonably to know what had actually occurred between the supervisor and the employee.
Yes. And in this case, we have the evidence of Mr. Bramwell before...
Well, I know we have his evidence, but we also know that the IDT rejected his evidence and accepted the account given by Ms. Spence of what had taken place between them.
Yes. But they didn't reject that evidence.
Well, I'm just looking at what Court of Appeal said. The IDT clearly rejected Mr. Bramwell's explanation for signing the leave form. It must have accepted Ms. Spencer's testimony that Mr. Bramwell had given her oral approval of the leave and that she omitted to sign the relevant portion of the form by oversight. It's 1602.
Yes, I'm saying that they only came to that conclusion after hearing Miss Spencer.
Yeah.
Mr. Goff,
Yes, my lord.
I'm sure I've misunderstood it, but I thought that the tribunal really, in concluding that the leave had been authorised, wasn't relying on Miss Spencer's evidence or anybody else's oral evidence. It was relying on the document on which Mr. Bramwell had endorsed. She's currently off, which had then been filed by the leave clerk and dated by the leave clerk. So I had understood that this was really all decided by reference to the documents. And I think I'd collected that from page 72, if that's to hand for you.
It is, my lord. In page 72...
At 11, 4 lines down from the top, this tribunal considers it quite reasonable to infer Mr. Bramwell had intended to approve the leave, and subsequently did, when he affixed his signature to the leave forms and wrote she's currently off. And so for you to be lengthily making submissions about the oral evidence given and whether it was admissible or inadmissible might be missing the point, which is the tribunal says, look at the document.
Very well, my lord. The document itself, of course, and the signing of it occurred while she was overseas. Now, the fact that they have accepted here is not the evidence necessarily that Ms. Spencer gave. I admit that. Because Ms. Spencer said that I did receive formal approval because he sent me to fill it in. But the tribunal, in fact, has concluded that it was reasonable to infer that he had intended to approve the vacation leave and subsequently did so when he signed the document. Now, this is an inference that they're drawing, which is actually contrary to the evidence of both parties. One party...
It's a conclusion of fact, isn't it?
Yes, but a conclusion
Are
of...
they not the sole judges of the facts?
But it then would be...
IDT, they might be wrong, but so what?
Well, in that case, it would be a conclusion of fact made without any evidence to support it.
No, that's an entirely different question.
Which is actually one of the grounds of the judicial review. What we had said was that there was no evidence to support that an intention to approve. Mr. Bramwell said the exact opposite. There was no evidence that when he signed it, he was retroactively approving it. He said that he spoke to the leave clerk and said to her, what should I do? Because she has gone off. And he didn't explain to the leave clerk that he had not approved the leave. And the leave clerk told him that he should just make a remark in the column that she is currently off. So he told the IDT, I was simply acting on her advice. That's what he says to her, to the IDT. I never intended to approve her leave. I went to the form, the leave clerk told me that that's what I should do, and I simply followed her advice. So, and it's not even a case where Ms. Spencer was arguing the opposite. Ms. Spencer was saying, forget the signing of it. Ms. Spencer was saying, you sent me to fill in these dates, and that is formal approval. I don't need to sign it anymore. So I'm saying that they've actually found a fact here which nobody ran, which nobody put before them. So, and that's why they say that it's reasonable to infer. That's because there is no evidence.
Of course, you could be completely right on the law, that it has to be judged by what the employer knew or ought to have known at the time the employer made the decision.
Yes, ma'am.
But the IDT have been completely right in finding as a fact that this is what the employer did.
Well, that takes us to the point, milady, of whether, would that be a question that the Employment Tribunal in any other country would do?
Yeah, they'll certainly investigate what happened.
Oh, yes. In the context, of course, of what the employer knew at the time. What we're saying is that the question that they should be asking is, based on the information that you knew, which may very well include their assessment of the evidence of Mr. Bramwell, because they could have rejected Mr. Bramwell's testimony. Based on the evidence that you knew, was that a reasonable decision? But what has actually happened here is that we are taking it from the perspective that the Industrial Disputes Tribunal in Jamaica is now conducting disciplinary hearings. And this is where I'm stepping now out of UTEC's case and stepping into Jamaica Employers Federation case. Because the questions that they asked are being asked in a wide variety of circumstances. We produced for you the Juicy Beef case, where someone was accused of theft. And applying the judgment of the Court of Appeal in this particular case, the judge said that he is bound by the decision and that the IDT asked itself the correct question, which was, did he actually commit the misconduct in question? And what's happening now is that we are having disciplinary hearings twice. Once at the employer level and once before the IDT. And the only difference is at the IDT level, the employer goes first and doesn't know what...
Maybe, but that's the system. But surely paragraphs 10 and 11, in the context of paragraphs 1 to 9 on pages 70 to 72, are simply conclusions of fact, which can't be challenged.
The question, though, my lord, is if it had been a case of theft, would they be allowed to...
About this particular case,
yes,
these particular findings of fact, I suggest to you they're findings of fact, and that's all there is to it. And if they are findings of fact, you're stuck with them. You may not like them, but you're stuck with them.
Certainly, my lord. Then in that case, we would rely on the argument we ran before the Supreme Court, which was that there was no evidence for support those findings of fact. And that is how they would be impeachable. That was run in the Supreme Court.
Well, you also ran the argument that they shouldn't have been making those findings of fact because the question was a different one.
Yes, Ms. Lee, we ran quite a good number of arguments. Yes. But I'm responding specifically to this issue here. Of course, I'm here representing the Jamaica employees.
But here we have the evidence recorded. So I don't follow how you can say there's no evidence to support it.
The evidence to support...
For example, Miss Dawkins' initial ... I mean, all that's the evidence. Primary fact found by the Tribunal of Fact.
The evidence of Mr. Bramwell's intention, my lord, certainly is not. The evidence of Mr. Bramwell's intention certainly is not.
Well, the paragraph 11 is an inference of fact of his intention. That's another kind of finding of fact.
Yes, my lord.
And you can't challenge it.
If I could
say there's no evidence in support of it, because here is the evidence. Might or might not be good evidence. Maybe if I'd been the finding of fact, I wouldn't have found it. But I'm not.
The larger question, though, my lord, is it the case that the Industrial Disputes Tribunal should be asking themselves the question of whether or not misconduct has been committed? Or is it only the situation where, on the facts of this case, because it was a particular type of misconduct involving essentially the employer and what he said or didn't say, we could even put that one side. But the question here is, this case is actually being relied on to say that the IDT asks itself the correct question by inquiring whether or not the misconduct has occurred. And so in the case of theft, they ask themselves, they don't ask themselves whether the employer, don't anymore, any longer, ask themselves whether the employer had reasonable grounds for believing the theft had occurred. They ask themselves, well, can you prove that the theft occurred? And that's
well, before this decision in the Court of Appeal, Were there Jamaican authorities that said all you've got to look at is reasonable grounds?
There were, my lord.
Well, we might look at the strongest of them from your point of view.
Yes, madam. We have the case, the IDT itself in the JPSCO case. It's not in the bundle of authorities, but it can be supplied to you. It's 87 pages long. I thought I was sparing you. But we make,
and you're sparing of us.
we make reference to it at page 1677. In our case, page 14 of our case. On page 14 of our case, we first indicate that we were told by Mr. Dixon in no uncertain terms that the IDT has always applied British Home Stores test. And that my understanding about it, which is that they don't, is incorrect. Now, Mr. Dixon was one of the original members of the IDT. Longest serving member of the IDT up until his death in 2015. So there it is that he is saying that we, in the last 30 plus years, have always applied English law, the British Home Stores in particular, though he seems to make a distinction about it. He says that we're not applying the case, we're simply applying the judgment of Justice Arnold. And the entire transcript is on your memory stick. We go on further, that in 2006, even before this exchange, there was a decision of Jamaica Public Service Company Limited and the National Workers Union where there is a majority award of the IDT in which they expressly apply British Home Stores.
So where do we see that?
I'm checking to see if it's...
What's the name of the case?
It's Jamaica Public Service Company Limited and the National Workers Union. I don't believe it is in the... I don't believe it is...
On this analysis, we don't seem to have any of the relevant authorities.
Well, we've got lots of authorities to which you don't refer, but those to which you do refer are not in the bundle. However, that's I'm sure
I can...
gratuity.
I actually have the case in soft copy right now. I could provide it to you during the break today. But in that case, that 87-page case, as I said,
we look forward to
the minority award was done by Mr. McNish, who was also the panelist in this particular case. And in this case, he says that he is the one who rejects the application of British Home Stores on the facts of the case. He says that British Home Stores is not applicable because in that case, the employer's disciplinary policy provided for an objective test, whereas in his opinion, British Home Stores is a subjective test. Now, I think we can argue as to whether British Home Stores is in fact subjective. It is both subjective and objective. But he believed that it was inapplicable on the facts of the case. But the majority applied it and upheld it, which is corroborating the statement that Mr. Dixon said, which is reproduced in our case. The point here, my lords, is that the Industrial Disputes Tribunal intends to apply British Home Stores. It tries to apply British Home Stores, but it fails to apply it. And we also have in the...
So critical. It'd be interesting to know what British Home Stores says.
Well, we do have that.
You do have that.
Oh, we certainly got British Home Stores. Yeah.
You certainly have British Home Stores.
Yep.
And you certainly have the juicy beef case, which comes after this case, in which the IDT itself argued that British Home Stores is applicable. And that was accepted by the judge.
So where do we find the juicy beef case?
It starts at page 1945. So in the juicy beef case, I'll take you to it right now. Paragraph 12 on page 1949. It says, in this case, that dispute is whether the employee was justifiably dismissed. Whether or not this is so is dependent on the answer to the questions. Did the employer honestly believe? Did the employer have a reasonable or credible basis for that belief? And very importantly, did the employer carry out a fair process of investigation, popularly called a hearing, prior to dismissal? Support for this may be found in British Home Stores Limited and Burchell, per Justice Arnold. What the tribunal has to decide every time is whether the employer who discharged the employee on the ground of the misconduct in question, usually, though not necessarily dishonest conduct, entertained a reasonable suspicion amounting to a belief in the guilt of the employee of the misconduct at that time. That is really stating shortly and compendiously what is in fact more than one element. First of all, there must be established by the employer the fact of that belief, that the employer did believe it. Secondly, that the employer had in his mind reasonable grounds from which to sustain that belief. And thirdly, we think that the employer, at the stage at which he formed that belief on those grounds, at any rate at the final stage of which he formed that belief on those grounds, had carried out as much investigation into the matter as was reasonable in all the circumstances of the case. He then continues, in Jamaica, the Labor Relations Code is relevant to providing an answer to the third limb of the test propounded by Mr. Justice Arnold. He then refers to this case and says that the Jamaican Court of Appeal in the Industrial Disputes Tribunal versus University of Technology Jamaica and the University and Allied Workers Union has stated categorically that the IDT's inquiry is, and look how he phrases it, not to be limited in the manner decided in the Burchell case. So after applying the Burchell case, he interprets it that the court is not to be limited, or rather that the IDT is not to be limited to Burchell. So you can use Burchell, but you are also to go on further and look at all the other circumstances of the case. But certainly, there is an embracing of Burchell. And in this case, the IDT appeared, was represented, and argued this position. So what has happened here, my lords, is that the IDT didn't argue this in the particular case before you, but they have argued it before, and they have certainly argued it since. But look at paragraph 15. It goes back to the point I'm making, which is relevant to all employers. Even if we say that UTech doesn't fall within the ambit of this case. But look at what happened here. Justice for Appeal Brooks concluded on this point. I'm now reading from the top of page 1951. In my view, the IDT asked itself precisely the correct question, namely, was Ms. Spence's absence from work authorized? I am bound by this decision of the Court of Appeal of Jamaica. It is clear that in the case before me, the IDT also asked itself a question in similar vein. See page 6 of the award. Firstly, quote, did the worker, Ricardo Nation, remove the property of his employer without permission, end quote. And in this regard, the tribunal concluded, on the balance of probability, the company might well have had cogent reasons to dismiss this worker for unauthorized removal of its property. What is happening here, my lords, is that the IDT is actually conducting a disciplinary hearing. They are actually asking themselves the very same question that the employer had to ask and resolve, and substituting their discretion for the employers in so doing. No, the IDT was never set up to be resolving questions like this. It was never set up to be determining innocence or guilt, in the same way that the Employment Tribunal in England doesn't do that either.
On the facts found by the tribunal, you lose whichever test is applicable, because the tribunal says, university, look at your documents. You had them, and they mean the leave was authorized. So on that basis, even on British Home Stores, there were no reason, you had no, or the employer had no reasonable grounds to dismiss. So, what's it all about?
My lord, I can accept that the University of Technology's case may not be on all fours with the type of cases that British Home Stores was looking to deal with. But again, I'm here for the Jamaica Employers Federation.
You can say the law is as we say it is, and I accept that on that law, UTEC should still have lost.
Lady, could you repeat?
You can say,
Yes.
I think my lord is putting to you,
Yes.
that we, the board, could say that the law is as you say it is. That is, the matter has to be judged on what the employer knew or ought to have known at the time the employer made the decision, and it is not for the tribunal to depart from that, although it is for the tribunal to find out what the employer knew or ought to have known at the time. You can,
And as I
we can say all of that, and we can still say that for the reason my Lord Wilson has given you, UTEC should have known what it had written in his own documents, should have interpreted those properly, and should therefore have concluded that the leave had been authorised, and therefore the declared ground for dismissing her was not made out.
Yes, my lady.
All of that is possible, is it
Absolutely, my lady. And we have, and that's not new. Our position from the Court of Appeal has been that if they had approached it from the perspective of saying, what did UTEC know, or what they ought reasonably to have known, if they had found that UTEC ought reasonably to have known that Mr. Bramwell has authorized the leave based on the document, him signing it, if that had been their answer, my lord, we wouldn't be here. Because we would have failed on the right test, as opposing to have failed on the wrong one. So that has been consistently our position. The problem that we have is that they are not consistently applying the test. And as we see from the juicy beef test, the juicy beef case, when they do apply the test, they're applying it incorrectly.
Yeah, this is a sort of examination, a moot question, isn't it? In truth. That on the facts, you're going to lose on any basis, whatever the test is.
On that
Vary
vote,
whether we should be considering that. I mean, Ms. Spencer, who's the person who's basically concerned with all that, would be entitled to succeed on either basis.
well, succeed on the question.
Matter which.
Indeed, my lord, but remember that that goes to the question of whether the dismissal was justifiable or not. There is another question, and that's the remedy. Because it doesn't flow that if you are unjustifiably dismissed, that you should be compensated in any way, or you should be reinstated. And from the university's perspective, that was actually the bigger issue. The main issue that UTEC had, and still has because she's there working today, is that even after it was declared that she was dishonest and deceitful, even after she perjured herself at the IDT and produced...
Now, this would be a completely new basis of claim, would it? Perjury or...
Yes. But even after her dishonesty in the face of the IDT, that she was rewarded with reinstatement. And the university was required to take back her dishonesty.
Has this been a live point so far?
Oh, it certainly has, my lord. It certainly has.
Has anybody decided it?
Yes, in Justice Brooks has said, well, Justice Mangatal first said, again relying on a number of authorities, that the information that comes to the employer's attention after the dismissal is relevant to the question of the appropriate remedy. Because otherwise you'd be putting a premium on dishonesty.
Why is she still working then?
Because the Court of Appeal reversed that. The Court of Appeal said that even though if the IDT had known about her dishonesty, they may have spared the university from taking her back. The fact is that that was a procedural error on their part, and he felt constrained to leave it alone.
Could you just give us the reference to that part of their decision?
On page 1595, paragraph 28 of the judgment. Paragraph 28 reads, the aspect of the evidence concerned firstly the refusal to admit the contents of Miss Spencer's passport.
So sorry, paragraph what?
28.
28.
Yes, ma'am.
Thank you.
The aspect of evidence concerned firstly the refusal to admit the contents of Miss Spencer's passport into evidence. Actually, that's not quite correct. It wasn't a refusal to admit it. It was a refusal to order her to produce it. And secondly, allowing Miss Spencer to give evidence in respect of the matter in dispute. Justice Mangatal ruled that the IDT ought to have granted UTEC's application to have Miss Spencer produce her passport. In her judgment, although it would not have affected the question of whether Miss Spencer had been unjustifiably dismissed, it would have been relevant to the issue of whether she should have been reinstated. In paragraph 31, I'll take it to 30. I, however, agree with Justice Mangatal that UTEC made its decision to dismiss without knowledge of Miss Spencer's whereabouts. I also find, as Justice Mangatal seems to hint, that in light of the contents of the passport, Miss Spencer's actions in respect of the week before 5th of June and the 2 weeks after 20th July 2006 were dishonest and deceitful. Had the IDT considered the contents of her passport, it may well have decided to allow truth to have its effect. It may have, independent of the question of unjustifiable dismissal, decided that UTEC was entitled to be spared having an employee who behaved in that fashion. I remind Ms. White and the IDT that truth is the cornerstone of the edifice called justice. I also adopt the words of Martin Luther King Jr. when he said, quote, without justice, there can be no peace, end quote. Those words are applicable to the industrial environment. He then goes on to explain that he believed it was a procedural issue, and because they are masters of their own procedure, he couldn't interfere. Of course, my lords, in judicial review, procedural impropriety is an independent head of review. And that is the basis on which we had made the claim. We had said that refusing to admit her passport wasn't merely a matter of procedure over which they had control, but it was an error of law amounting to declining of jurisdiction.
But Your whole case before the tribunal was, we never gave permission for that leave. That was the issue before the tribunal. So can one really criticize the chair of the tribunal when you get up and say, I'd like to see the passport, please. I'd like an order about that. Can one really criticize the chair for saying, Mr. Goff, the issue you've laid before us is whether it was authorized. How can where she went during her leave be relevant to authorization? What was wrong with the chair's response to your application?
What was wrong, my lord? Well, firstly, it's not a situation of admitting the document into evidence. There's a higher threshold when you're admitting evidence as opposed to when you're asking to see a document. Disclosure, as it were. Because there are no rules of disclosure at the IDT. And as the union said in this case, they don't have any obligation to assist you to make your case. So the first aspect of it is that we're not looking at it from the perspective of admitting evidence, but rather producing it. Secondly, the chairman did think it was a reasonable request. He said so when the application was made. And then when they said they weren't going to do it, he said, well, I don't think it's relevant to the question of dismissal, which is entirely correct. But the point here, my lord, is that it's a two-stage process. Separate and apart from the issue of whether the dismissal was whether the leave was authorized or not, which goes to the question of whether the dismissal was justifiable, you have an entirely separate issue now in relation to the relief and the remedy that you're going to order. And if, as the Court of Appeal says, it was relevant to the remedy, then refusing to order it does amount to a decline of jurisdiction. And that has not been challenged, that it was in fact relevant to the remedy. And that is the bigger point for UTEC. The bigger point for UTEC is that by drawing the line at the date of dismissal for the purpose of the employer only, and allowing the employee to produce this information that comes later, you're putting the employer to disadvantage, and you're putting a premium on dishonesty.
Can we read where you make your case for the order for the production of the passport?
Yes. We specifically said that based on this information that's coming out, it seems likely to us that these medical certificates which are in evidence are forgeries. We said that because based on the evidence that she had been leading on cross-examination, she actually said that she could have been overseas on one of the days stated in the medical certificate. We asked her, could you have been? She said, I don't remember. Is it possible that you were overseas on this date? And she says, yes, it's possible. And then when we said to the tribunal, how can she say, on the one hand, it's possible that she was overseas, and at the same time, she's admitted into evidence a certificate from a doctor in Jamaica. And she actually said, I went to visit the doctor twice. So there was already this inconsistency on the evidence in cross-examination. And we said specifically, if the passport shows that she was overseas on this particular date, that would mean that she has perjured herself and these are forgeries. And they still refused.
Can I ask you, we don't have a great deal of time left, can I just ask you about one matter arising from the IDT's judgment? The argument you're presenting to us, as I understand it, is that whether or not the dismissal was justifiable has to be judged on the basis of the information which was available or reasonably available to the employer at the time when it took the decision to dismiss. And Ms. Spencer didn't attend the disciplinary hearing, and so her explanation wasn't something which ought properly to be considered in deciding whether or not her dismissal was justified or justifiable. Now, the IDT found that following the union's involvement of the Ministry of Labour, the practice is, as they put it, once the Ministry of Labour is invited in a matter involving the parties to a dispute, the discussion regarding resolution of the dispute cease until the matter that caused the Ministry's intervention is sorted out. And so the Tribunal regarded it as reasonable for the union not to have taken part in the hearing because of the Ministry's intervention. Yes. And they say they accept Ms. Spencer's explanation that she left it up to the union to administer the dispute on her behalf. This is all at pages 74 to 76. Now, if that's right, then I think the implication of that is that one can't treat the employer's state of knowledge as at the date of a disciplinary hearing as conclusive, because the whole point of what's being said is they shouldn't really have gone ahead with that hearing, and it's only now in front of us that the whole story is properly being investigated.
Yes, Millard. Quickly, I'll respond to that.
Yeah.
Firstly, Justice Mangatel dealt with that in length and ruled that it was entirely proper for the university to proceed with the hearing. And neither the union nor the IDT appealed that aspect of the decision. And they couldn't have really when faced with all the facts. Firstly, there was evidence that there were in fact two separate disputes. That the dispute that the ministry had invited UTEC to was a dispute over the procedures and not a dispute in relation to, of course, her dismissal. Secondly, on cross-examination before the IDT, the union officer conceded that the first dispute had been settled. Thirdly, a dispute between parties over the rules and procedures at the university is not something that the Ministry of Labour or even the court had the power to inquire into because the university has a visitor. Fourthly, conciliation is not mandatory in Jamaica and has never been. Based on all of that, the learned judge, Justice Mangatel, came to the conclusion that there is no evidence of any established practice requiring an employer to halt its internal disciplinary process whilst a matter is pending before the IDT. And since then, my lord, as far as I know, the ministry has not acted in a manner inconsistent with that ruling. And they tell employees, go to your disciplinary hearing, and depending on the outcome, you may come to us. And then again, that harks back to the Labour Relations and Industrial Disputes Act, which speaks about what a dispute is. And a dispute is where there is a dismissal or a suspension. If you look at Section 2 of the Labour Relations and Industrial Disputes Act. And the judge also found that what was being referred to as a dispute over the procedures at the university didn't actually meet the standard of a dispute in law. So for all of those reasons, my lord, the that issue has not proceeded any further. It's really not a live issue before the board.
Could I just ask you one, I hope, final question? Is it the practice in the IDT to deal with both the substantive question, the justifiability of the dismissal, and the remedy in the same hearing?
Yes, my lady, absolutely.
Because in employment tribunals in this country, it's very common practice to deal with liability first, remedy second, in two separate hearings.
Well, that's not the practice in Jamaica. And as you see it in the juicy beef cases.
But it would make sense, wouldn't it? On your submissions, it would make sense.
Oh, absolutely it would.
Because something which is not relevant to liability can come in at the remedy stage, but won't take the decision on liability.
Yes. And in fact, there are quite a number of matters which come in on the liability, on the remedy stage, including factors such as whether the employee has found, gainful employment since the dismissal. There are a whole host of factors which perhaps could be in a separate hearing, but are always done after the question of unjustifiability has been determined. And as I was saying, in the juicy beef case, you see that's exactly what has happened. That having found as a fact, on a balance of probabilities, that Mr. Ricardo Nation had actually removed the property or stolen goods, they say that they are not going to reinstate him. And they give him minimal compensation, which is exactly what the employment tribunal in England would have done in those circumstances. And the case of Davis and Atkins is really the leading authority, that House of Lords case is really the leading authority on that point. And we rely on it.
Thank you, Mr. Goff. Does that complete your submissions?
There were some additional submissions that we had, milady. I'm not sure if you would prefer us to reduce them into writing.
Well, if you have anything extra, we have, of course, read your very full written submissions in any event. But if you have anything extra to add, particularly in response to the note with which you have provided, we will happily receive those in writing.
Did you say that you were kindly going to give me the reference to the transcript before the tribunal of the argument between you, then on behalf of the university, and Miss Spencer's counsel about whether there should be an order for production of the passport?
Yes, my lord. If you look at page 1000, that's where the chairman says it's not an unreasonable request. But it actually is after he comes back and changes his mind.
And where do we get the argument? And obviously we're interested in the arguments that Ms. Spencer's counsel put forward too.
It was in two parts, because at first we made the request, and we gave the basis for the request, and the chairman said it was reasonable. That's on page 1000. And then...
Chairman says, let's hope she can find it.
Let's hope she can find it, that's right. And then when he comes back, having had a good weekend, he thinks that it's no longer relevant. But the argument is... Crave indulgence, give me 1 second. If you look, I think, on starting 1035. No, 1034. The chairman asks, hold on a second, why do you want the passport? It goes on from there. 1034, line 6. And the line about the fictitious certificates is on 1038, line 12.
Thank you.
Is there any point made on remedy? The relevance of the passport to remedy?
Before the IDT, my lord?
In this transcript?
Oh, yes.
Where?
What I just said, 10 what? I'm not sure if it was before the IDT. I think it certainly was before the...
Oh, well, that's quite different.
Was it or not before the IDT?
I had understood you. I mean, you're such a competent and totally honest advocate. I had certainly understood you to be saying that when you made your application to the Tribunal for the order, you had said plainly, sir, this could be relevant to remedy. So after all, Mrs. Justice Mangathol is reviewing,
Yes.
it's only a review, reviewing the way in which the Tribunal dispatched the procedural application.
My Lord, I think that harks back to what Milady Hale had indicated. I think at that point in time, the remedy, to be speaking of the remedy, presupposes that there's been a ruling against you on liability.
I thought you told us that they were the same, that they all took place at the same time.
That's the point, my Lord. That if it had been a case where we had already at that point in time had a ruling against us on liability, then perhaps we would have been more clear on the fact that this goes to remedy. But at that point in time, when we were making our submissions, they hadn't even as yet determined the question of liability and the justifiability or not of the dismissal.
We'd like to adjourn for 5 minutes just to have a little talk about what we do from now on. Mr. Goff, if you'll just give us a few moments, we'll adjourn. Mr. Goff, we've got quite a dilemma in this case because there are so many different courses that we could take. We could, for example, conclude that you were right on the law and the role of the IDT, but on the facts of this particular case, the university loses in any event. You accepted that we could reach that conclusion. And of course, you'd be, on behalf of the Federation, completely relaxed about that. That is one thing we could do. But of course, if that were what we did, what we say about the law would strictly be obiter dicta. So it wouldn't be very helpful to you. But that might be what happens. We could, of course, say that you were wrong on the law and everything is fine. We could do that. And so we would dismiss the appeal. But if we were to say that you were right on the law and the role of the IDT, in a way that might be ratio decidendi, binding on the whole world in Jamaica, we might be a bit concerned to do that without having heard argument from somebody else. So we have it in our minds that we might wish to ask for an amicus to come and argue in whatever direction such an amicus might. Now, we haven't made any conclusions yet. We are considering this case, which is causing us considerable interest and not a little difficulty, and you'll understand why. So we understand that you may wish to make further written submissions in answer, in particular, to the note that our judicial assistant did for us. But if you would like to make any observations on whether or not it would be appropriate, given the importance of the issue, for us to ask for further assistance from Jamaica on this, please include such observations in your written submissions. And indeed, any observations on whom might be approached for such submissions. Should it be the Attorney General, for example, or should it be the IDT itself, who are, of course, technically respondents, and so in a way they would be the right people to ask. I know they've said they're not going to, but if they thought that there was a substantial chance that the board might say that what they're currently doing is wrong, and they think that what they're currently doing is right, they might wish to come, or whatever. That's the position that we are currently in.
Can I ask them, Lady Hale, if we were to do the route of amicus, that would just involve written submissions, or would they be?
Well, we would be reluctant to put everybody to a great deal more expense in journeying all this way, especially in the cold. But on the other hand, of course, you may enjoy your trips to London. We know not. We do not wish to inquire into that. But we certainly don't wish to add to the expense which this case has already caused, if that's unnecessary. So written submissions might very well be sufficient.
My lady, this case is so important to the Jamaica Employees Federation that if that were your view, that we should return, we would happily return.
It's so important to the employers. You'd have thought equally it was so important to the union. Now, the union, as you know, has written to say, Miss Spencer has not put us in funds, we cannot appear. But, I don't think you can comment on this, but I find it curious that the union doesn't realize the importance of this appeal from the point of their members generally.
Well, I could shed a little more color on that, my lord.
Thank you.
I don't think that it's correct to say that they have not been put in funds. They didn't actually use the word funds in the letter. They were very careful to avoid it. What the university has seen is that Ms. Spencer has written to the university to say that the union no longer represents her interests. So I don't know if that may well be a part of what they're referring to when they say that she hasn't put us in a position to represent.
Oh, I see.
And the second point is in relation to the IDT as well. My understanding, because we have tried on numerous occasions to get from the IDT, not only whether they're coming, but why they're not coming. And insofar as it is relevant, I spoke with the current Solicitor General, and she said, not necessarily connected to this case, but it was her view that the IDT isn't really a party. It should be treated more like a court. And it is guided by whatever the Privy Council says, one way or the other. It doesn't really have an interest or a position in the matter. And that also may color how we go about whom we approach to do it.
Well, this is a point that had occurred to us. It's, if the IDT is a judicial or quasi-judicial body, it's in principle unsatisfactory if it is called upon to justify its own decisions. It should be the people with an interest in the outcome of its decisions who defend those decisions.
I mean, it's really an employment dispute, isn't it? On the one hand, between the employers and the union, they're the people who ought to be represented. I mean, just looking at the thing more generally.
Just as the Federation has taken over from the employer, there must be a trade union congress in Jamaica.
There is.
Well, perhaps they would be.
And the union could be an intervener, just like you.
Indeed, they could.
Is there anything more you'd like to say, Mr. Goff, at this stage?
At this stage, my lady, I sense that it probably would be better for me to put it in writing. But what I will do, though, my lady, today as well, is I will let you have copies of the Post Office and Jones case as well as the JPS case where they did apply British Home Stores by majority decision.
Yes.
And that will be done today.
Well, that would be very, very helpful. Thank you very much indeed. I can say on behalf of the whole board that we're very grateful to you and no doubt to your learned junior for the assistance that she has been in presenting this case. We very much enjoyed listening to your submissions. Speaking entirely for myself, I would be entirely relaxed about your having to come back again.
I think we'd all be very relaxed about that.
I'm grateful.
So in a sense, we will consider whether we are in a position to tender advice to Her Majesty after we have received your submissions, and we will let you know our decision in due course. Thank you very much indeed. The court is now adjourned.